여러분 안녕하십니까?
Good morning.
2021 국제 특허법원 컨퍼런스에 오신 것을
Welcome
진심으로
to
환영합니다.
2021 International
저는
Court
오늘 개회식의
Conference.
사회를 맡은
Today
특허법원의
I will
정희영
be the
판사입니다.
moderator. I am
국제
Judge
특허법원
Chong
컨퍼런스는
Hee-young.
올해로 제7회를 맞이하였습니다.
This is the 7th
이렇게 뜻깊은
IIP
행사의
Court
사회를 맡게 되어
Conference.
무척
It is an
영광입니다.
honor
그럼
to be the
지금부터
moderator for such an
2021 국제
meaningful
특허법원
event.
컨퍼런스의 개회식을
So now we
시작하겠습니다.
will begin the opening ceremony.
(2021) 국제 특허법원 컨퍼런스는 코트,
The
IP and
conference
harmonization이라는 주제로 세계
is held
IP
under the
전문
topic of court
법관들과
IP
전문가들이
and
경험을
harmonization,
공유하고
and we are
상호
joined
이해를
by
촉진하기 위해
experts and judges from
마련되었습니다.
around the world to
아쉽게도
share
작년에 이어
experiences
올해
and
역시
insights.
코로나 상황이 지속되고
Unfortunately,
있어
as we did
완전한
last year,
대면적
we
학술
are
교류
still
행사의
going
형태는
through the
이루어지지
COVID
못했습니다만
pandemic, and
지금 이
we are
자리는
holding a
여기 계신
virtual
현장
conference, but
참가자분들
still,
외에도 전 세계
here
10개국 법관 및 IP
on
전문가들이
site we
온라인
have
생방송 또는 사전
IP
동영상으로
experts
자리를 함께
from
하고
around the
계시며
world
국내의
joining
많은 온라인
from
참가자들이 본 행사를
the
지켜보고
online
계십니다.
platform.
시간 관계상 일일이
Due to time
소개해드리지 못하는 점
constraints,
양해
please
부탁드립니다.
understand that I cannot introduce each and
이어서
every one of the
2021
participants in
국제 특허법원
detail.
컨퍼런스의 홍보 영상
So
시청이
we will
있겠습니다.
watch a video for the promotion of this conference.
올해의 컨퍼런스의
The
주제인
meaning of
코트 IP and
court IP and
harmonization에
harmonization,
내포된
which is the
의미와
subject of this
특허법원의
year's
과거,
conference, and the
현재
past,
미래가
present, and
잘
future of the
응축되어
patent
소개된
court
영상인
were
것
well
같습니다.
captured in the promotion
특허법원은 제가 지금
video.
몸담고
I
있는
currently work for the
법원입니다만
patent
이렇게 홍보
court, so
영상으로
it
바라보게
made me
되니
very
굉장히
proud and I
감회가
was very
남다르고
moved watching the
자랑스럽다는
promotion
생각도 듭니다.
video.
그러면 제7회
So
국제특허법원
now I would
컨퍼런스의
like
첫
to
문을 열어주실
introduce
특허법원
the
이승영 법원장님의 개회사가
speaker for the
있겠습니다.
opening
큰
remarks,
박수로
Lee Seung-young, the Chief Judge
모시겠습니다.
of the Patent Court. Please give him a round of applause.
안녕하십니까?
Greetings, everyone.
저는 대한민국 특허법원장
I am
이승영입니다.
Sung-young Lee, the Chief Judge of the Patent Court
2021년도
of Korea.
국제특허법원 컨퍼런스에 참여하시는
I'd like
여러분을
to extend my warm
진심으로
welcome
환영합니다.
to all of you attending the
올해로
2021
제7회를
International
맞이한
IP Court Conference.
국제특허법원
This year marks the
컨퍼런스는
7th anniversary of the International
2015년에
IP Court
처음
Conference.
개최된 이래
Since its inauguration in
세계 특허 소송의 주요
2015,
쟁점에
the
대한
conference
실무를
has
논의하기
brought
위하여
together renowned
여러
IP
나라의
court judges and experts from
IP
around the
담당
world to discuss
법관과
in depth
전문가들을
key
초청하여
issues and practical
각
affairs
주제에 대한
relating to
심도
IP
깊은 토론을
litigation.
이끌어내는
And
IP
now,
분야의
the conference is recognized as the world's leading forum for international academic exchanges in the IP sector.
작년에 이어 올해에도 코로나19의
There
전
is no
세계적
doubt that the
확산으로
global
인해
COVID-19
여러 나라
pandemic
사이에
posed daunting
대면
challenges
접촉을
to all of
통한
us last year
활발한 교류가
and yet again this year,
크나큰 도전에 직면하고 있는
preventing many
상황인 점을
countries from
부정할
engaging
수
in
없습니다만
active in-person
그럼에도
interactions.
불구하고
Yet,
과학과
we have
기술의
all come
발달은
together here
실시간
using various
온라인
means,
참가 등
including a virtual
다양한 방식으로
platform enabled
여전히
by
우리가
science
한자리에
and
모일 수
technological
있게
advancements.
올해 컨퍼런스의 주제인
This year's theme, Court IP and Harmonization,
지식재산권과
was
관련하여
selected to
국가별,
compare and
세대별,
understand how
직무별
different
대립과
countries
반목,
around the world
나아가
are addressing
그
the
기저에 깔린
IP-related confrontations and
문화적,
animosities between
가치관적
countries,
차이에서
generations, and
여러
functions, as well as underlying conflicts
합리적으로
coming from
해결하기 위해
economic,
세계 여러
cultural,
나라에서
and value-related
어떠한 방식으로
that
노력하고 있는가를
differences.
비교법적으로 고찰할 수 있는 자리를
So
마련하고자
this is indeed
선정되었습니다.
a very good opportunity to look into these issues.
위와 같은 대주제 하에
Under
올해 국제특허법원 컨퍼런스
Grand theme,
11월 10일과
we will
11일
discuss various
이틀 동안
topics for 2 days from November 10th to
세계
11th.
여러
We'll
나라의
first look at
IP 소송
the recent
현황을
trends in IP
대략적으로
litigation
살펴보고
in different countries,
이어서
and then
코로나19 백신 개발과
talk about
관련하여
how other countries are
특별히
granting
관심이 집중되고
compulsory
있는
licenses, a
강제
topic
실시권
that has
제도에
garnered
대한 여러 나라의
much attention
운용
recently with the development of COVID-19
4차
vaccines.
산업혁명 시대를
And then
대표하는
we'll look into how other countries are dealing with the patent law issues relating to artificial intelligence.
컴퓨터 프로그램에 대한 여러 나라의
Afterwards, we'll move on to how
저작권,
countries are protecting computer program
법적
copyrights.
그리고
We'll then
사용자와
discuss
종업원의
how to strike
이익
a
조화를
balance
모집하기
between the interests of
여러
employers and employees
직무
with regard to
발령명
employees'
관련
inventions.
논의를 순차적으로 진행한 다음
And so, after
한국,
proceeding in this
독일,
order,
일본의
the
IP
conference
전문 법관들로
will
구성된
culminate with a moot
고위중재
arbitration
행정부에
session where IP court judges from Korea, Germany, and Japan will come together and come up with the most reasonable way to work out the compensation for the inventor in a hypothetical case.
오늘 영상으로 축사를 보내주신 존경하는 김상환 법원 행정처장입니다.
Kim Sang-han, who is
이상민
the
국회의원
Minister of National Court Administration, and also to Mr. Seo Byung-soo, we would like to thank you for your welcoming remarks, and also we would like to thank Marco Alman, the Assistant Director General of WIPO, and also Sang Jo-jong, Chairman and President of Council on Intellectual Property, for your keynote
2년
speeches.
가까이 이어지는
The
코로나
pandemic
팬데믹으로 인해
that has lasted for almost 2 years is making things
시간적,
tougher
장소적
around
차이에서
us.
오는 온라인 참가의 어려움에 불구하고
Yet many IP court judges and experts from Australia, China, Germany, India, Japan, Switzerland, Turkey, the UK, and
중국,
the United States were undeterred by the inconvenience of virtually participating from various different time zones.
IT 담당 법관과 전문가들께 이 자리를 빌려
So I would like to
다시
take this
한번
opportunity
감사의
to extend
말씀을
my
드립니다.
deepest gratitude to all of you once again for being here to provide your invaluable input and
세계 여러
support.
나라의
I believe that
IP
the
담당
International
법관과
IP Court Conference
전문가들
will
사이에
develop into a
지혜와
pivot
경험을
of the
나누는
international network
소중한
where IP
국제
court judges and experts
네트워크의
around the world
발전해
share their
나가기를
wisdom and
희망하면서
experiences. I
바쁘신
hope that all of you
함께해
have a
주시는
truly fruitful
참가자
and
여러분들
mobile time
모두에게
here at the
이번
conference.
컨퍼런스가 참으로
thank you
유익하고 오래도록 기억에
for taking
남는
time out of your busy schedule
즐거운
to
시간이
attend
되기를
today's event.
기원합니다.
I hope you enjoy
감사합니다.
today's program. Thank you very much.
네, 이승영 법원장님 감사합니다.
Thank you, Lee Seung-young, the Chief Judge of the Patent
다음은
Court, for your remarks.
김상환 법원
Moving on,
행정처장님의
we will
축사가
hear
있겠습니다.
congratulatory remarks from Kim Sang-hwan, the Supreme Court Judge and Minister of National Court Administration. He wasn't able to participate in person, but he sent us a pre-recorded video.
안녕하십니까?
Greetings to you all.
법원행정처장을 맡고 있는
I am Sang-hwan Kim,
김상환입니다.
Supreme Court Justice and the Minister of National Court Administration. It is my honor to deliver congratulatory remarks for the 2021 International IP Court Conference on behalf of the Judicial Branch of Korea. Congratulations once again on the opening of this conference.
2015년 처음 개최된
I am pleased to see that the conference has grown every year since 2015 to become a venue for exchange and communication among IP specialized judges in the world.
기쁘게 생각합니다. 이번 컨퍼런스는
This year, the conference is held both online and offline as in last year because of the COVID-19 pandemic.
먼저 귀한 시간을
First of all,
참여해 주신
I want to extend my gratitude to experts from home and abroad for joining us in spite of busy
또한
schedules.
시차와 거리를 극복하고
Many
온라인으로
decided to join us
컨퍼런스에
online
참석해
despite
주신
time zone differences and long distances.
각별한
I
감사의
want to
말씀을
express my sincere gratitude to the judges and experts from many countries. As you are well aware, the pandemic has caused concerns about infectious diseases and brought challenges that prevent us from meeting others and having close communication in
인류의
person.
건강과 생명은 물론
We are facing an unprecedented crisis in all aspects, from human health and life to socioeconomics.
그러나 역사를
Nevertheless, history is a continuation of challenges and responses.
코로나19 치료제 개발과
We are overcoming the crisis through developing a COVID-19 treatment, vaccination, and global response and cooperation.
나가고 있고 가까운 시일
We
내에
expect
이전의
to
일상을
return to
회복할
normal
것으로 기대하고
in the
있습니다.
near future.
이러한 의미에서 코트 IP
The theme of this conference, Courts, IP, and Harmonization,
최근 이슈가 되고 있는
comes from this
코로나19
background.
백신
We will
개발과
discuss
관련한
issues that involve patent rights and the COVID-19 vaccine development and explore different cultures and rules in each country. We will also discuss disputes and solutions, which makes this conference very timely and pertinent.
지식재산권은 기술과
IP
문화의
rights have
발달을
led the
이끌고
advance
이를
of technology and
통하여
culture,
인류의
resulting
번영에
in
이바지하여
prosperity and
이러한
humanity.
지식재산권을 둘러싸고
If there are
현실적으로
institutional or
발생하는
cultural
제도적,
disputes that
문화적
happen
갈등이
in
있다면
practice,
이 역시 각국의
I
실무가
firmly believe that
전문가들이
experts and
머리를
practitioners from
맞대고
different
지혜를
countries
모아
can share wisdom
슬기롭게
and
해결해
join
나아갈 수
efforts
있으리라
to find
믿어
sensible
보시기
solutions.
바랍니다. 각국의 지식재산권
We are
전문가들이
joined by IP experts who will participate online and offline to share experience and wisdom.
그 자체로
I believe this
컨퍼런스의
very
주제인
fact embodies the theme, Court, IP, and Harmonization.
잘 드러내는 것이라고
very well.
생각합니다. 오늘부터 이틀간
The
개최되는 이번
conference is held
컨퍼런스에서
today
펼쳐질
and tomorrow.
세계 지식재산
The IP experts
전문가들이
around the world will
다양하면서도
join
심도
in
깊은
depth
논의들은
discussion
우리
in
인류의
various
삶을
topics.
더욱
This will be the foundation to
풍요롭게
enrich and
만드는
harmonize
자양분이 되리라
lives of
믿습니다.
humanity.
나아가
In addition,
2021년 국제 특허법원
I wish
컨퍼런스의
that the success
성공적인
of the
개최를
2021 International IP Court Conference will enhance the ties and cooperation among IP courts all over the world.
끝으로 귀한
Many
시간을
people
내어
took time
컨퍼런스에
out of their
참여해주신
busy
모든
schedules to
분들과 안전하고
participate.
내실 있는 컨퍼런스 개최를
Chief
위하여
Judge Seung-Young Lee and
여러
others put
노고를
great effort
아끼지 않은
into this fruitful and
특허법원
safe
이승영 법원장님을
conference.
비롯한
I would
관계자
like to
여러분께
extend
다시
my
한번 감사의
gratitude
말씀을
to
드립니다.
all of them once
여러분
again.
모두의 건강과 행복을
I
기원합니다.
wish health and happiness.
감사합니다.
Thank you.
다음은 2021
next,
국제 특허법원 컨퍼런스의
To wish for the successful holding of the 2021 International IP Court Conference, many people sent their congratulations. So National Assemblyman 이상민 and 서병수 sent their video messages. We will hear the video message from National Assemblyman 이상민 first.
국회의원 이상민입니다. 제7회
Congratulations on the opening of the 7th International IP Court Conference. It is meaningful that the conference is held in a mixed form of online and offline under the difficulties due to the COVID-19 situation. My special thanks go to Chief Justice Myung-soo Kim of the Supreme Court of Korea for his support, and Chief Judge Seung-young Lee and judges from the Patent Court of Korea, as well as all the organizing members who have worked hard to hold this conference. I'd like to express my appreciation to judges and legal experts from the US, China, Germany, the UK, Australia, Switzerland, Japan, Turkey, and India for joining the event over the internet. And I'd like to thank all on-site participants also. The International IP Court Conference has become one of the representative and leading international events for academic exchange in IP since 2015. Under this year's theme of Court IP and Harmonization, I believe the conference will provide a great opportunity to share the wisdom and efforts of each country to address conflicts and disputes related to intellectual property in a reasonable manner. Most of all, discussions on compulsory licensing and artificial intelligence is highly timely and interesting. It is all the more relevant as Daejeon City is a mecca for those working in science and technology fields where not only IP-related government agencies such as the Korean Intellectual Property Office, the Intellectual Property Trial and Appeal Board, and the International Intellectual Property Training Institute, but also tens of advanced research institutes, including KAIST Chungnam National University, are located. Once again, as a co-chair of the World Intellectual Property Hub Promotion Committee and the Fourth Industrial Revolution Forum of the National Assembly, I congratulate the opening of the 2021 International IP Court Conference, and I wish all participants of the conference health and happiness. Thank you.
다음으로 서병수
Next, the
국회의원님의
National
축하
Assemblyman
영상을 시청하시겠습니다.
서병수 has also sent a video message. We will watch it together. Honorable Chief Judge Seung-young Lee, IP specialist judges, experts from both home and abroad, distinguished guests, greetings. I'm Byung-soo Seo, a member of the People Power Party in the National Assembly from Jingu, Busan City. It is my honor to deliver congratulatory remarks for the 7th International IP Court Conference. I would like to welcome IP specialist judges, professors, and legal experts who are joining the conference via online. Also, although COVID-19 persists, there have been efforts to clarify issues linked to IP rights. And I would like to express my respect to the judiciary and the Patent Court of Korea for their continuous efforts to gather insights from globally renowned experts. The 21st century is characterized by rapidly changing science and technology. With the advancement of science and technology, the importance of IP rights is increasingly growing. We're also witnessing more complex disputes and conflicts in the IP area. As a co-representative of the National Promotion Committee for the World Intellectual Property Hub for the 21st National Assembly of Korea, I truly understand that IP is crucial and that we must resolve disputes and conflicts. These are prerequisites for a sustainable society and its development. Going forward, I will continue to study policies related to IP and also focus on legislative activities for the development of IP rights. I hope this conference will serve as a venue to identify global standards of IP lawsuits with reason and harmony. And I also wish the conference a resounding success. Thank you very much.
바쁘신 일정에도 불구하고 본 행사를 위해 축하
I would
영상을
like to
보내주신
thank
의원님과 서병수
Honorable
의원님께
Assemblyman
다시 한번
Lee Sang-min and
감사의
Seo-byung-soo for
말씀을
sending
드립니다.
pre-recorded congratulatory remarks despite their busy schedules. This brings us to the end of the opening ceremony of today's conference, and we will kick off the actual conference with two keynote speeches. Our first keynote speaker is the Assistant Director General of World Intellectual Property Organization, Marco Alleman. Dr. Alleman was a practicing IP rights attorney since 1995, and from 1999 he joined the WIPO in Geneva, Switzerland, and he now is the Assistant Director General of WIPO, where he leads the IP Innovation Ecosystem Department. We will watch his keynote speech.
Honorable Minister of National Code of Administration,
존경하는
Justice
김상환
Kim
법원
Sang-won, Honorable
행정처장님,
Member of the National Assembly of Korea, Lee
존경하는
Sang-min and
이상민,
Soo Byun-soo,
서병수
Honorable
의원님,
Chief Judge Lee Sun-jong of the
존경하는
Patent Court
이승용
of Korea,
특허법원장님,
Honorable Professor John Sen-jo, Chairman of the
존경하는
Presidential Council on
국가지식재산위원회
Intellectual
위원장
Property,
정상조
distinguished
교수님,
judges and dear
존경하는
friends.
국가님, 그리고
It
내일
is a
기빈
great
여러분,
honor for me to address you at this
제7회
seventh edition
국제
of
특허법원
the
컨퍼런스에서
International
기조 연설을
IP
맡게 되어
Court
큰
Conference.
영광으로 생각을 합니다.
I thank the Patent Court of Korea
이
for the
자리에
invitation
연사로
and
설
the
수 있게
opportunity
초청해
to
주신
address you.
특허법원에 감사의 말씀을
The
드립니다.
Patent Court of Korea, established in 1998, is one of the
1998년도에
first
개원한
specialized
특허법원은
IP court
아시아
in Asia.
최초의 지식재산 전문 법원 중 하나로 계속해서
It
혁신을
introduced
이어나가고
an
있습니다.
international division in 2018,
2018년도에는 국제재판부를 설치하여서 외국어 변론과 서면 제출이 가능하도록
The goal
하였습니다.
is to provide affordable
목표는
and convenient
한국
judicial
지제
services
소송에서
to
비중이
foreign
점점
parties
커지는 외국인 당사자에게
whose
적정한
presence
비용으로
is growing
편리한
in
사법
IP
서비스를
litigation in the
제공하고자
Republic of
설치된
Korea.
것입니다.
The patent court's openness to the world is
세계를 향해 열려
also
있는
seen
특허법원의
in this
면모는
IP court conference,
이러한
which is running in
특허법원
its seventh
컨퍼런스에서도
edition,
잘 나타나고 있는데요.
attracting
올해로
leading jurists
제7회를
from
맞이하고
across the
있습니다.
world
전 세계
to share
유수의 법률
their
전문가들께서 식견을 나누고자
This year's
함께
conference
해주셨습니다.
theme is called
아시다시피
IP and harmonization.
올해 컨퍼런스의 주제는
As you
Court
know,
IP
WIPO is a
Harmonization입니다.
global convener
잘
for the
아시겠지만
discussions on intellectual property
193개
matters,
회원국을 보유한 와이퍼는 IP에 관한
and
국제적인 논의에
harmonizing global
장을 열어
IP norms
글로벌 IP
with
규범을
a
세우고
membership
조화를
of
이루어 나가는 기구입니다.
193 member states. Since the 1883 Paris Convention for the Protection on Industrial
1883년
Property
공업 소유권의
and
보호를
the
위한 파리 협약과
1886 Berne Convention for
1886년
the Protection
문학
of
예술적
Literary
저작물의
and
보호를
Artistic
위한
Works,
베른 협약은
those
19세기
express the desire for harmonized legal protection of intellectual property work in the face of the globalization resulting from the transport and industrial revolution in late 19th century. The broad historical trend toward harmonization and integration of the IP system at the multilateral level has slowed down in recent decades, owing to difference among the interests of stakeholders in the system. We can observe a move away from multilateral solutions toward regional and bilateral approaches, as well as to different plurilateral efforts. Even in areas where there is convergence in laws and governed by international treaties, important difference may remain in domestic law and more so in the application and interpretation by the court. The series of Dabus rulings that is currently in the limelight is a very good example. It concerns a patent application filed in some 17 jurisdictions where Dabus, an artificial intelligence machine, is named as the inventor. CAIPO and a number of other IP offices, such as the European Patent Office, the USPTO, the UK IP Office, refused the patent application. Unsurprisingly, the case is now being litigated in courts in different jurisdictions. The Federal Court of Australia issued the first judicial ruling on this question in July of this year, deciding that an artificial intelligence system can be recognized as the inventor for patent purposes. The UK Court of Appeal and the US District Court for the Eastern District Court of Virginia decided in September and in October respectively that an inventor must be an individual and rejected the patent application. So while much has been achieved in terms of harmonization in the area of substantive intellectual property law, there is place to accommodate difference. The difference are more apparent in the judicial application and interpretation, which are inherently national and territorial. The sovereignty of national judicial structure and the intimate connection with the territory would make it unsuitable to address harmonization in the context of the core. Instead, we may talk about global judicial dialogue, which may take different forms. When a court is tasked to resolve a novel IP question, the court may monitor, review, and be informed by foreign judgment that address similar legal programs. And in appropriate circumstances, cross-reference to the foreign may be well appropriate. And the cross-pollination of judicial approaches will help not only when the reasoning of the other court are accepted, but also when courts depart from the approach of foreign courts. There are important reasons why the solution developed in one jurisdiction may be inappropriate elsewhere. Achieving coherence and mutual respect between divergent legal systems and distinct judicial structure through information exchange, while preserving judicial independence in domestic adjudication, is crucial for the predictability and legitimacy of national judiciary. This is the approach promoted in the WIPO work with the judiciary, and with a program of cooperation and exchange of information and experience among judges that have been put in place. This year, WIPO IP Judge Forum expects some 400 judges from 80 different countries participating, and I really look forward to seeing many of you there. WIPO will continue to engage closely with the Patent Court of Korea and with the judges participating in the IP Court Conference, to support an effective and balanced approach to IP adjudication that is suited to the domestic framework of each country and at the same time respond to the demands of the modern interconnected global IP ecosystem. Thank you for your attention, and I wish you a stimulating discussion over the next 2 days.
다음으로 국가지식재산위원회 정상조 민관위원장님이 기조연설을 해주시겠습니다. 정 위원장님은 서울대 법대 교수로 지식재산권법 연구와 강의를 하고 계시고 서울대학교 법과대학장 및 법학대학원장을 역임하셨으며 각종 정부의
And
정책이나
he has
운영에
been
관한
serving as an
지원 활동을
advisor
계속적으로 수행하고
to the
계시면서
policymaking functions of the Korean government. And currently, he is the private sector chairman of the President Council on Intellectual Property. I'd like to now invite Chairman Jung for his keynote speech.
우선 마스크 벗고 우선
First and foremost, congratulations on the opening of the 7th 2021 International IP Court Conference.
초청해 주신 이승영 원장님께
I'd like to thank Judge Lee Seung-young for inviting me to speak at this conference.
코로나 위기 속에서도
Amidst the COVID-19 crisis,
세계 국내 그리고 해외
we are joined
저명한
by
판사님들
honorable judges, professors, and attorneys from home and abroad as panelists for today's event. I'd like to thank all of them. It is my great delight to be joined by their presence.
어려운 여건에도 불구하고
Despite
특허법원이
this difficult circumstances,
컨퍼런스를 개최해서 이제
Patent Court holds this conference every year. So,
법관들이
now the conference has established itself as an international forum where judges in Korea and abroad share their experiences and information, deepening their mutual understanding.
이번 컨퍼런스는
This year's conference aims to search for wisdom needed to address the IP-related disputes
찾기 위한 것으로 알고 있습니다.
based on insights
전 세계적으로 경제적인
around the world.
가치관의
Many conflicts are emerging due to economic, cultural, and value differences.
컨퍼런스가
This is why I believe it is very timely that harmonization was selected as the theme of this year's conference.
원장님께서 좀 시간을 여유 있게 주셔가지고 제가
Well, I was allotted ample time by the chief judge, so I prepared a rather long speech.
이쪽으로. 예, 감사합니다.
Thank you.
최근에 첨단 기술 분야에서 핵심
In the
지식재산을
recent cutting-edge
둘러싸고
technology field,
미국과 중국의
the hegemonic competition between US and China
냉전에
is intensifying. It is even dubbed as the new Cold War by some.
백신의 신속한 글로벌 공급을
Also,
위해서
whether IP rights for COVID-19 vaccines should be waived,
그 여부에 관해서 각국의 이해관계에 따라
this
찬반이
became a
첨예하게
hotly
대립하고
debated
있습니다.
topic among countries with different
지식재산권은
interests.
이제 경제와
Intellectual
통상을
property
넘어서
is not just an economic or commercial matter, but a matter of national security and public health.
바로 이런 배경에서
For this
지식재산권에
reason,
관한 국가 간 갈등이
conflicts among nations surrounding IP issues are escalating.
enforcement
Of IP rights is gaining much attention from around the world.
국가 간 갈등은 사실은 조약의 체결에
Conflicts
의해서
among nations can be addressed by signing treaties to achieve harmonization among different IP laws. Advanced and developing countries have signed WTO and TRIPS to agree on the minimum level of IP protection,
지제법의 조화를 추구했습니다.
thereby achieving such harmonization.
한편으로는
Meanwhile,
WTO에서의 보호 수준에 관한
there has
불만으로
also
인해서
been a movement to sign
양자 조약
bilateral
내지
or regional
지역별
treaties
조약으로
to secure a higher level of IP
강화하려는
protection,
시도가
as some
진행 중입니다.
countries were not satisfied with the level of protection ensured by the
다른
WTO.
국가 간 갈등이 심각해지면서
At the same time,
WTO 체제
intensifying
자체가
conflicts among nations
도전받고 있습니다.
have put the WTO system itself at risk.
지제권 분쟁에 있어서도
The WTO
체제가 무능하다
has revealed
이런
that its
지적이 나오고 있고
has revealed its incompetency in dealing with IP
공중보건의
disputes
의약품의
between
활용에
nations.
있어서도
And
WTO가
the organization is
된다.
also
이러한
criticized for
지적을
getting in the
받고
way of
있습니다.
utilizing essential medicines for
20년 전에
public health.
WTO TRIPS가
20
공중보건을
years
위해서
ago, for public health, the
의약품 특허의
WTO
강제 실시
TRIPS
Compulsory license를 허용한다.
made the
소위
Doha
도하
Declaration
선언을
allowing compulsory
했습니다.
licenses of
그러나
patent rights on essential medicines for public
코로나19
health.
백신과 치료약에
Nevertheless,
관한
there
특허권의
is still a long
포기나
way to go
강제
to put
실시
into practice
또는
patent
영업
waivers,
비밀의
compulsory
공개는
licenses, or
유언한
trade
것이
secret disclosure
명백한
for
현실입니다.
the COVID-19 vaccines.
사실 도하 선언 직후 미국의 부시
Immediately after the
정부는
Doha Declaration,
에이즈 치료가
the
공중보건의
then
중요한
U.S. Bush administration came to
과제라는 것을
realize that
직시하고
AIDS treatment is an important initiative for public health, investing
제네릭 의약품을
for the
활용하자.
treatment of
여기에 동의하고
AIDS
무려
treatment,
18조 원,
investing almost 18 trillion
투입한
Korean
바가
won,
있습니다.
which is close
미국
to
정부는
15 billion
에이즈
USD dollars
대응을
for the
위한
use of
대통령
generic
비상계획.
medicines. The U.S. government launched the United States President's Emergency Plan for AIDS Relief,
비상계획을 수립하고
PEPFAR,
약 100조 원가량의
and has so
예산을
far
투입해서
allocated roughly 100 trillion Korean won to the plan, leading the AIDS prevention and treatment efforts by 50 countries. As a result, they were able to save close to 20 million people's lives.
대응을 위한 대통령 비상계획은
The PPFAR has not taken any stance on compulsory licensing of patent rights of medicines, but it practically allowed it practically allowed the use of generic medicines.
제네릭 의약품을 활용하지 못했다면
Had it not been for that initiative, saving those 20 million lives would have been impossible.
21세기 최대의 위기를
In order to effectively respond to the 21st century's biggest crisis, COVID-19,
효율적으로 대응하기 위해서는 도하 선언을
we should address the challenge of putting the Doha Declaration into action for effective response.
각국 정부가 막대한 예산을 투입해서
It is clear
코로나 백신과
that
치료약을 개발했습니다.
in fact, many governments have developed vaccines through heavy investment. It normally takes around 15 years, but this time, in response to COVID, vaccines were developed in merely 1 year. It shows the wonderful accomplishment in science and technology that humanity has achieved. Containing the spread of coronavirus quickly is an essential task in the best interest of the entire humanity. In this regard, India, South Africa, and many member states have been arguing that the WTO should apply temporary patent waivers to COVID-19 vaccines and drugs. Nevertheless, despite the Doha Declaration, most of the advanced countries that develop vaccines and cures are still standing in the way of patent waivers and trade secret disclosure. Patent rights do promote the development of vaccines and treatments, but at the same time, it can also hinder the extensive use of vaccines and treatments. This is why we need a balance between patent right protection and broad use of technology, and we're in a dire need of wisdom to harmonize different interests of different countries.
발명이나 창작을 촉진하기 위한 지적권은 본질적으로
IP rights designed to promote invention and creation are fundamentally different from the ownership of an
위한 도구적인
object.
성격의 권리입니다. 그래서 지식재산권법은
IP laws inherently are framed to have balance and harmony to achieve certain legal purposes. The Patent Act not only stipulates provisions on patent right protection, but also exceptions for the purpose of compulsory licensing, research, and testing. In the same vein, the Copyright Act also prescribes not just the copyright protection, but also the provisions on fair use and limitations on copyrights. But whether such provisions and exceptions are actually realizing the balance that we are aiming for, this remains questionable. The regulations and exceptions are difficult to harmonize, in large part due to the COVID-19 pandemic. The COVID-19 pandemic upended our lives and brought upon an accelerated digital transformation. Well, lectures in colleges, music concerts were canceled, and they were replaced by a virtual, non-contact forms of lectures and concerts. Now, we no longer go to actual theaters to watch movies, but do so over our phones at home. And with less personal contact, we started talking with chatbots instead of actual human beings. Rather than going out to restaurants, we prefer to order in our meals. Rather than shopping at brick-and-mortar marts or shopping malls, we are moving to online platforms to order what we need. And COVID-19 has also ironically stimulated the advancement of science and technology for the vaccine development. Such changes are all common in the fact that AI lies at the very center of all this transformation. It wasn't the actual virus, but the cutting-edge AI technology that has brought upon such groundbreaking changes to our lives. AI is becoming smarter because it learns a large amount of data. All of you judges have studied arduously to become judges, but AI, in order to perform tasks, they read larger amount of data and employ self-learning. AI was able to draw this painting of Edmond de Bellamy because 15,000 pieces of artwork was learned by the AI, which would be impossible for a human painter to do. Also, in order to hold casual conversations between lovers, this robot has learned 10 billion conversations. Oxford, Cambridge, Harvard, Stanford, Yale, the libraries of all these prestigious colleges with 25 million books were scanned, and this was all learned by the AI, and 5 billion search results are being learned by AI in real time every single day. As we are transforming to such non-contact way of living and use of AI, the issues of fair use surrounding such AI technology remains very cloudy. The current IP law provisions and limitations on rights are far from striking the balance. Many are questioning the effectiveness of the current system applied to AI. Copyright, trade secret, database rights are all
권리와 청구권이 있습니다.
rights and claims that are in our legal system currently, but limitation of rights is very unclear.
10년 전에
Well,
미국과
our
마찬가지로
copyright 10 years ago, as the US did, introduced a general provision on fair use in order to strike a balance between protection and use of copyright. But in reality, provisions on fair use being applied to a new technological environment is a new challenge that is difficult for us to respond to and foresee, because the nature of the problem itself may change. This is before the introduction of fair use provision, but to aid searches, unauthorized collection of photo images to create a thumbnail to be provided to internet users was a case that was addressed. The Korea Supreme Court ruled that the thumbnail image would serve the public interest in a way that it was not used for its artistic or aesthetic value, but to provide the internet location information of the photo, thereby making searches more convenient. The court found that although such thumbnail image was provided for commercial purposes, it still constitutes fair quotation, fair use. Even though this Supreme Court ruling was on fair quotation, it is interpreted to be acceptable as the judging criteria for fair use as well. AI is significantly increasing the volume of data that can be utilized. Businesses are using data for commercial purposes, and despite such for-profit usage, there's still no clear rule on what kinds of data used by AI constitutes fair use. According to the U.S. court rulings, transformative use is considered as a critical element. There was the Google case where the U.S. Court of Appeals found that the act of scanning, such as the 25 million books that were scanned, and digitalizing and using of a copyrighted work for book search purposes constitutes transformative use and is therefore considered as fair use. Transformative use is also considered as an important element in determining what constitutes fair use in Korea. This is what I expect. However, it is still unclear whether Korean courts will deem artificial intelligence's data analysis as transformative use. No one can be sure of how it will play out. Well, such uncertainty surrounding the issue of fair use, a number of assemblymen proposed a bill to amend Korea's Copyright Act. If a value can be added by analyzing a large amount of copyrighted data, copying or transmitting such data shall be considered as fair use within the scope necessary for data analysis, and thus is not infringement of copyright. So fair use of data for data analysis, if it is not in order to enjoy the idea or emotions contained in that data, but is simply used for analysis, then it would fall under the scope of fair use. Therefore, it is important to distinguish between the two cases, which is close to what the Japanese Copyright Act has in place. But this is only limited to the cases where the data can be lawfully accessed. Therefore, if spiders or crawler bots surf the internet, whether their free access of data also falls under this category remains unclear.
데이터의 활용이 중요하다고 보고 저작권법 개정안을 제출한 의원들이 있는가 하면
Unlike these
정반대로
lawmakers who propose to amend the Copyright Act, recognizing the importance of data utilization, other lawmakers believe that we need a much stronger data protection. These
데이터 활용이 더 중요하다고 생각하는
lawmakers place more emphasis over protection, on protection over utilization,
법안들이 많이 상정되었습니다.
and have also proposed many bills to that effect.
기술
These lawmakers tabled a bill to amend the Unfair Competition Prevention Act to expand the legal protection of data.
부정경쟁 행위에 해당한다.
If a significant amount of data on technology and business is collected and managed electronically, any unauthorized use of such data should be deemed as an act of unfair competition, and there is no exception allowed in the amendment for data analysis purposes.
자산에 대한 법적 보호와 활용을
So,
위한 이 법안들이 최소한 5개가
There
상정되었습니다.
are at least 5 bills that are pending with relation to this issue. If these are actually legislated, then
데이터의 과잉 보호 또는 데이터 활용의
a
위축으로
potential overprotection could
모든 법안들이
lead to
법률로 제정되지는
undermine the utilization of data. So we would have to keep a close eye on which bills will actually be legislated and how they may be amended, reflecting the actual needs in practice.
균형과 조화는 사실은
Well,
지재권으로
balance
인한 형사 처벌
and harmony in the area of IP laws become more important in the context of criminal punishment against IP infringement. This is because criminal punishment has more far-reaching impact on invention and creation than a civil liability. The bloody code may undermine the balance and harmony in IP law, and this is a phenomenon that may be unique to Korea. The Korean Supreme Court recently ruled that even an act of providing an internet link can be punishable when it aids and abets a violation of public transmission rights. Is this really culpable as aiding and abetting a violation of public transmission rights? Has a different nature, I believe. There are websites where music or movies are posted without obtaining consent from the copyright owner, and if you provide a link to such website to gain advertisement earnings, knowing that posting on such a website is an act of infringing the copyright, the provision of rerun services, such an act constitutes aiding and abetting copyright infringement according to the ruling. However, a link is a key means of sharing information and enjoying freedom of expression on the internet. Therefore, utmost caution should be paid when a link is used as a ground for determining an offense of aiding and abetting a crime or a joint illegal act. Korea's Supreme Court also clarified the requirement of willfulness in order to recognize an offense of aiding and abetting copyright infringement by using a link. And there should be sufficient knowledge of the fact that the principal offender is infringing the copyright. However, interpretation of this willfulness requirement is a tricky issue. So, compared to other advanced countries that take great caution when enforcing criminal punishments against copyright infringement, Korea's copyright law and court rulings seem to be leaning more towards protection of copyrights, which makes us wonder whether we are truly realizing the right balance. There has been criticism that the Korean courts underestimate damages and damages claims relating to IP right infringement. Failure to recognize damages at a reasonable level could undermine the protection of IP rights. To address this problem through legislation, the KIPO amended the Patent Act, Trademark Act, Design Protection Act, and Unfair Competition Prevention and Trade Secret Protection Act to introduce punitive damages. Punitive damages are adopted by the US and many other countries as well. But we must keep in mind that these countries allow punitive damages in patent infringement, but do not enforce criminal punishment against patent infringement. We also have criminal punishment provision on patent right infringement. So adopting punitive damages on top of that would be an extremely rare case, probably the only case. And this could lead to consequences of double punishment or excessive sanctions. A proper next step would be to eliminate the criminal punishment provision, as we have the punitive damages provision in place. In order for our IP law enforcement to strike the right balance and achieve harmony, I think the courts need to be stricter in demanding and interpreting the willfulness requirement that I mentioned. Employees' invention is the topic of one of the sessions of this conference. Employees' invention is a difficult and important issue that requires effective coordination and balance between the interest of the employer and the employee. The employee's rights over employees' invention, whether it will be transferred to the employer and receive compensation, is to be governed by the agreement between the two parties. But the Korea's Invention Promotion Act stipulates that the employer is obliged to pay compensation to the employee, but the issue here is the amount of the so-called reasonable compensation. The employer's profit coming from the service invention, the compensation rate, the contribution rate of the employee are all factored into the calculation of the compensation. This directly affects incentives for invention for the employees. Therefore, it is critical to strike the right balance surrounding this issue. On the other hand, if there is no agreement or service regulations specifying compensations for employees' inventions, the employees have still the right to claim reasonable compensation. We cannot always forward such cases to the court, and it would make it difficult for the employer to foresee its profits. Therefore, we have to focus more on the actual purpose of the Copyright Act when dealing with such issues. The protection and utilization of data requires harmonization from around the world. Balance and harmony surrounding IP rights should not only be discussed domestically, but it is an issue that should be dealt through a global, joint effort. At today's International IP Court Conference, I'm greatly honored to have honorable judges and attorneys and experts. I hope that input and insights from our renowned participants will greatly contribute to the realization of such balance and harmony in the IP law field. My speech was rather long, but thank you for your attention.
Chairman Chung, thank you very much. I think it was a very meaningful keynote speech that really cut through the very theme of this year's conference. It gave us a lot of food for thought. Once again, why don't we give him a big round of applause.